Chief already has the matter with right. Here, my lord, petitioner is the L1. He was quoted the earlier tender call notice in item number 14 and became the L1.
Item number the
Thereafter, my lord, what happened? It was supposed to be opened on 17 February. They didn't open on that date. So they opened it on 20th April of this month, my lord. And when that after he found that already re-tender has already been another such annexure one, another notice has been floated. And the tender committee.
And after floating a fresh tender, he reopened the earlier tender.
Yes, my lord. That is the case.
Here, madam, the matter become reproduction because the retender notice with respect to the work in question has been cancelled, my lord.
Cancelled.
No, let's get to the copy make consider.
Copy.
They are the experts.
Instruction, this is a
Notification. Obligation.
We have to pass an order. Give me that instruction. So the petitioner has challenged.
Earlier in C2.
3-2. So at that point of time, though you were not aware.
Not received also any
That
document
is
from
the
the
case.
authority and-
Straight away, if he was not aware that any work is awarded, it may be in the midst of the tender, if any other work is awarded, how can you penalize him for that? Can you foresee?
Government has.
So there was a disparity, that is the lordship sought for clarification. The page 101, what they uploaded, that is 6 to 2. last date of tender was 3/2/25. And now they have given the letter to us because we sought for clarification that whether this is the fact or not. They have said that it is 24/1/20. So that is why there is a disparity. Your lordship sought for clarification.
Correct. Now it appears he says on 6th it was only uploaded, maybe awarded, but it was not communicated to him.
Agreement as per the record showed that it was signed on 24/1/2025 by both the parties. Now, it's looking for all.
Agreement was executed on that, which was,
Annexure B by 2 at page 114.
no, I just wanted.
That is the
Agreement
intimate.
handover to original yourself.
Shows.
I have given, your lordship a directed on affidavit, I have given also. For the agreement.
So if you have executed prior there, you will.
I have, my case is I have not executed on 24th. I have not put any date in the agreement. Your lordship see, on the affidavit, I have filed the register. Issue register of that authority. I have received on 6th only.
No, I understood, but what is the?
On that day, I have signed, my lord.
But it appears that your signature is there on 24.
Yes, ma'am. Not 24, but I have not put anywhere my date, man.
Sir, what are you talking about?
See, and
You,
only
you, have you,
Why didn't you put? Why didn't you put?
your lordship.
So signature without date.
Yes. Why they are?
Signature without
But they
date.
have no choice also.
Has
No, sir.
They have no choice also. Your lordship.
No, sir.
Annexure 14, your lordship may see. When that has been issued to me, your lordship, for a moment, I have filed an affidavit. With more difficulty, I got it. Annexure 14, your lordship may see.
Whatever.
Your lordship may see for a moment, my lord. For a moment, your lordship say, if your lordship will not satisfy, then
Annexure 14 of the,
of affidavit I have signed as per direction of this one.
where is that affidavit?
Last page of my
No.
lord.
Yes,
Yes, ma'am. Your lordship may see. This is the issue register.
14.
Last one.
Page.
Last page, ma'am. 24 also. Yeah.
Yes.
But that is register of letter issued, my lord. They have issued it on 1108, your lordship may see, serial number. They have issued it on 6/2 and I have received the same on 6/2 when it has been uploaded in the website. On 6/2 they have uploaded it.
अच्छा ऊपर.
Yes, ma'am. And with next tender I have given it. Thereafter the complaint has been given to me against me by the other tenderer, my lord. By the time the documents are not with me, and for that reason I cannot upload that document.
How that agreement would bear a date of
My-
24/1?
Your lordship knows, we have no choice. The bidder has no choice to put the date. For that reason, he has not put the
So
date.
according to you, you have put a signature after 6/2.
On 6/2, my when I have received all these things, sir. And apart from that, your lordship may see the uploading of the online uploading. Your lordship may see,
No. Let me see.
my dear lordship may see 101, 101, my lord. Your lordship may see 101. They have uploaded, they have contracted 6 February 2025. They have written AOC. For that reason, they have stated my name. And next page,
column contract date shows 6/2.
6/2, my lord. Before that, there is no ongoing work, my lord. Apart from that, your lordship may see next 103. I have given before the authority 103. It has been digitally signed on 6/2/2025, the work order. We have no choice, my lord, because we have got a work, we have to execute work. And your lordship see 103. The digital sign is on 6/2/2025. That is the letter which has been stated that 24/1/2025, my lord. If at all I have knowledge about the issuance of work order and I have received it, I should have disclosed it, because in the next tender, very next tender, I have disclosed it and an allegation has been put against me. And thereafter I have been declared disqualified.
Essentially, as a question of fact, how do we know?
And this is not an ongoing work.
Document?
That was the receiving document,
What is a dispatch is done on 6/2?
normal, it's 6 to all the.
Is a register at the top, it is say register of letters issued. Issued means on the day when you issue a letter, on the top heading, what is this register? What is this register?
That is for communication.
I understand, for the communication. What is this letter? At the top, printed one.
This is work for the work, other things, that everything has been mentioned in the middle column.
Mr. Mahanti, Mr. Mahanti, page 101.
No, I have no issue. And let me make clarification.
No, he's taking a very neutral view.
Yes.
He says that since it was communicated to me, now ball is in there.
Allegation and letter received.
I have seen one of the columns that contract date. Contract date is 6/2.
They can clarify. I can clarify. But in the agreement itself, we have. How much?
We are not on agreement of this
Brother, where you found contract date?
101.
No, we have no issue. We can consider it.
That's all. 101.
This one dated 25/1/23/1.
No, sir, that
No, sir.
one column.
I tell you, from a civil side, I can share you. When a lease is executed, it has a duration.
Right.
Let us consider it that way. The commencement can be made anterior and the lease may be executed posterior.
Absolutely.
It can say that I have executed a lease today, but it will commence from an anterior date for the purpose of computation of the period of the lease. I was thinking in that line from the civil perspective. So the execution may have been made on a particular day, which is letter day, but the commencement will start from an anterior date. So 24, because I find their document also does not talk about the execution. It simply says the commencement, date of commencement, it is 24/1.
Right.
And the date of completion is 25/1. So it is a period which is to be counted.
Right.
Execution when it is done is a most important factor. I was just trying to find out what is the date of execution, not the date of commencement.
But the OPWD code provides, once the agreement is executed, the bidding process is completed. That means he had knowledge, the so-called notice was whether you have knowledge about the subsisting work, he says no.
No, that is when. Suppose
You
that
have
is
the so-called notification.
No. Please consider. He offered his bid. Please, what he is saying, if I understood,
Right.
he offered his bid or submitted his bid on 3rd.
I know. And of-
According to him, on 3rd, I was not aware that any work is awarded. I may have participated in various tenders. The work was awarded to me on 6th, that is 3 days after the submission of my bid. So on the 3rd, actually, I was not aware that it is awarded.
Right.
What he says. So anything which comes later, that he cannot be penalized because he cannot be said that he has given a wrong information. Ongoing means there must be an existing work allotted to him.
He is
Now,
not.
you said that the agreement was entered on 24/1.
Right.
So at least in the month of January, he was aware. And then he wrongly put that there is no ongoing nil.
No, my lord, only one question arises. From a perusal of page 96, a so-called notice issued. There, the question was, why you have not disclosed the ongoing process? Let me say, clarification. Why you have not disclosed about the pending work? He said, not that I had no knowledge. I received it after submission of the bid.
So
But
that is
he
the
had
main
knowledge.
That is the
But
main
he has the knowledge.
May I draw your attention to page 101?
My lord.
This is what he actually says. Contract.
In fact, we are saying to say, because they can
Mr. Samal, Mr. Mahanti, Samal would not be in a position to explain this, rather he will explain.
Yes,
Come to AOC table,
my lord.
3rd table, The fourth table,
Fourth table.
first line,
Contract date,
Contract date 6th February 2020.
they admit that it is not the signing date, the signature which puts the date, that is not the date. It is the contract date which is relevant. This is official document, sir.
But-
This is uploaded document.
When,
So this will not tell
my lord, when
false. Falsity can be,
Lordship is absolutely right.
sir.
When the work of this, the financial bid was opened and he became L1, he had knowledge. The moment the
no, sir. No, sir. I stand in the way. Sir, mere declaration that he is a L1 does not mean that the work has to be allotted to him. If subsequently, if he found that there is something, he may cancel the contract, he may do whatever he can do it, unless the work is executed or an agreement is executed, that will not be considered to be an ongoing work.
My lord, a letter of acceptance has been issued.
No.
Letter of acceptance has been
No,
issued.
no.
Letter of acceptance has been received by my lord friend.
No, there was stay order.
Mr.
In respect of that one.
Kindly explain this date of contract.
Yes, madam,
Yes.
what is this? What is this?
101, page 101, please explain.
Explain 101.
I have not the complaint, my lord.
No.
In fact, I have not filed the complaint.
Yes. No, that's why I said you will.
What is this contract date?
I became L1 subsequently.
proceedings ସରିଗଲା ପରେ ଯୋଉ ଅଲଗା ବିଲ୍ଡର ମାନଙ୍କର ଯୋଉ ISP ତ ରିଟର୍ନ ହବ
Sir, that can be updated.
ଅପଡେଟ୍
It is not updated date. You have written this contract date, not updated date. Both you have written 6-2. Both the columns under AOC, fourth table.
Sir, what she is saying absolutely false. May I use the very strong word false? Just go above that column. Updated by and updated on. Have you seen that? By and on. And then you say what is the contract date.
the contract
And just above the column, show him. Updated word is also used. Just above the column of A and C.
Yes, sir.
If you see, it says Mr. Devodatta Sahu and updated on 6. I can understand you have updated on 6. But why the contract date will be of this 6?
That means what he says may be correct.
No, that appears from a side.
Don't have an issue. We
No, I understand. I understand.
consider also.
We are on the.
Who is a complainant? You are not a complainant.
No, I have not the complaint. Complaint has not been noticed.
No,
Party.
no.
It is L1.
No, not this.
After financial bid is open, after his technical bid is cancelled, financial bid open.
I understand. If still you are a L1, no difficulty, the work will be awarded to you. No problem.
You will be
It will be awarded to you. If you are still a L1, there is no difficulty.
Yes.
He is out of the way. He made the complaint, same complaint, he has made an estimate. But he has not come before.
Yes, that's on 24/1, the agreement was executed because the work order is.
Sorry.
Alex, if I may refer to the work order, what he's trying to explain, Alex, the next page, 24/1, the work order has been issued. There, the language used is the work awarded to you after withdrawal agreement. So 24/1 contains the agreement, my lords. And this what.
Why the contract date is shown as 6th February? Contract means an execution of an agreement was done on 6th February. It is executed on 6th February.
As per executed on 24th.
Why then it is 24.
It is what he's saying, he's trying to say that it is uploaded on all.
There is a distinction. I have seen it is a commencement date is 24/1,
Yes, ma'am.
but not an execution date. What was the date of an execution? Contract may be executed later, commencement may come earlier, no problem.
And as per him, the contract was executed on 24th.
Where is the document showing then this document is absolutely, I would say, it's
Then why-
absolutely false.
Then why have you dispatched that letter on
On
6th?
6th, why you have dispatched this letter on 6th?
If it is signed on 24/1,
There is no necessity of sending a letter also. If he has come and signed the agreement, why you send a letter? He knew it. He has executed the agreement. Why you send a letter? What was the occasion to send a letter on 6? What was the occasion?
We know the dispatch register system. I know very well. So that's why I always verify this
No, sir, this is something, it aims at the different things, sir. It aimed at the different things. It is not so simple that we will go by that. No, it aimed something differently.
The competitive bidders.
Who has signed this document? Who has signed? This person.
Because after receipt of the allegation, it goes sought for clarification.
Mr. Bhanti, many
I
things.
understand. If it is, I tell you very frankly, if it is that he had a knowledge, what he says, no doubt he is out of it. Cannot.
May I draw your
But if it appears that there is something which is going on, then in that event, court cannot shut his eyes to a
right.
illegality which is perceived
Yes.
on the face of the record.
Right.
It is not the mouth version which is sacrosanct, it is the document which is sacrosanct. The document will speak, it will never lie.
May I draw your lordship's attention to another loopholes on the part of Bidco. Though I should not say, but I must be fair to your lordship. If your lordship will find the proceedings only saying that the allegation is received from him, allegation is received from me, nothing, no findings, then ultimately that is.
No, they confer a report from the SE.
So that will confirm, but
Don't say. They confer a
Yes.
from the
What should I
superintendent.
do? Should I direct to make a very expensive inquiry into the aspect that our authority, the vigilance department, we will direct that how this uploading, the person who has uploaded, on what basis it is uploaded, let there be an extensive inquiry. We'll record the stand of your officer and then make an extensive inquiry by the vigilance. And if it is found there is something fishy, then action has to be taken.
but your lordship kindly allow
And,
work to be executed.
If you come to page this
Yes.
answer B by 2,
425, the stay order, it is water supply. It is a work of water supply.
just that B by 2
Yes, madam.
agreement.
Yes, madam.
Acha.
We have the original.
Serial number 5.
We have the original.
5. Serial number 5. It is superintending engineer. Right? Come to bottom. 3 signatures I find. Superintending engineer, executive engineer, and somebody.
And the petitioner. The others.
No. Petitioner is left hand side column. But down below.
Inside 3 signatures.
Why these 3 signatures? If execution is done by 2, superintending engineer and the petitioner, then why these 3 of the same office?
He's saying that there is one is signed by the accountant, my lord. One is signed by the accountant. On the right hand side, it is signed by the accountant of the office.
Executioner.
And
See, why?
let's here on the side, it is accountant.
Is a greening signature. Greening.
Are you not seeing the seal? Seal of executive engineer.
Yes, madam. Yes.
Superintending engineer and the executive engineer. Who has executed?
Superintendent engineer, my lord.
Then why these 3?
This is the format in which
There is no format. Where is the format?
it's the P1 agreement which was enclosed with the tender document, my lord.
Then all the officers will sign it. No,
Which one is signed by the
you don't know. Where is the format? Show in law. Show it in law. ଆଉ କୋଉଥିରେ ଅଛି ସେମିତି କେବେ ଦେଖିଛନ୍ତି? ଆମେ ଏତେ କଣ୍ଟ୍ରାକ୍ଟ ଦେଖି ସାରିଲୁଣି କାହିଁ ଏପର୍ଯ୍ୟନ୍ତ ଦେଖିନୁ ତ? Meditate. Correct. We have.
Sir,
That is the original agreement.
yes.
I talk about the letter of acceptance.
Sir, আলু খোলো খোলো মহাদেব বাড়ি বাড়লেন
Letter of acceptance.
Very interesting. Now my brother, I did not have a practical experience on this regard. He might have, he appeared for the department for many years. He has more experience in this regard.
No, sir. Sure.
It's very interesting. I have seen the agreement. Actually, it bears 3 signatures at the top. First is the agreement deed. Agreement. The number of the agreement is given as 2425. You got it? Then the construction has been, name of the work is given. The AO and all, everything is given. Name of the contractor is given. Agreement value is given. Authority of acceptance is by whom? No signature. It's the superintendent engineer who has an authority. Acceptance. Correct? And then the date of commencement and the date of completion. That is there. And the others are, I think, not necessary. At the bottom, you will find on the left-hand side, the contractor has signed. On the right-hand side, 3 signatures are appearing. One is you have put a seal of a superintendent engineer, and he must have put his signature above the seal. Above the seal.
Yes.
On the left-hand side is an executive engineer is printed.
No, that is not there actually. What he is trying to say.
Sir, madam, then there is another signature, very small M.
That is by the estimator.
I am asking, I am coming, sir, estimator. Bear in mind, estimator. Let us not go that it is executive engineer. It is an estimator. Where then right-hand side, the greening, you say it is a accounts. Correct? Let us turn the page.
I don't.
You will find that the copy of the agreement has been forwarded to many officers on the very second letter. You have seen that? It is forwarded.
Yes.
Memo number. Additional engineer in chief, everything you have forwarded. But look at the above 8, yours faithfully, who is superintendent engineer. Then below it, accounting to you is a
On the left side is the estimate.
estimator. Let us be estimator. Then on the right side, accountant. Correct? In the bottom, you will find this estimator has put his signature and the accounts department has put his signature. In the first page thereafter, which starts Odisha Public Works Department, you will find all the signatures. Turn the page. Left, right, both 3 signatures. No problem. Turn the page. You will find how much? Left hand side, 3 signatures. Turn to the right hand side, blank. Who put? Not even a superintendent engineer. Estimator. Correct. Contractor has put. Turn the page. All estimator. Turn the page. All estimator. Turn the page. Even the conditions of a contract. Kindly visualize. You are a contracting party. Condition of a contract. Have you got that page? Who has signed? Estimator. Same signature, madam, if you verify.
This one.
Is an estimator. Where is the superintendent engineer? Where is that? Where is that? Tell me. Where is that? No, his contract will also go defective.
From page number 31, then again all of them signature sets.
Lord, you are even verifying certain blank papers also. And they are in a terms and conditions. You will not sign on each page. Do we believe? Even some of the pages, there is no signature. Madam, if you come at the bottom, the page number is given. Just I am asking. Come to page number 22 at the bottom. No, the signature of estimator is there. 24. 24. Has the superintendent or estimator put a signature here?
The estimator.
No. Page 24 at the bottom.
The estimator on the.
Sir, page 20, madam, page 24, I do not find any signature of the estimator. What are you talking about? Page 25, no signature. No signature. 26, no signature. 27, you will find a signature.
What is his designation, madam? Madam?
That shows that in hurriedly, madam, if you.
No, just a minute, sir. Sir, I'm putting that. What is his designation?
Additional chief engineer. Additional chief engineer.
Additional chief engineer. But the execution is made by superintendent engineer, you said?
What?
Accepting authority, you have put seal of superintendent engineer.
He's in charge.
And see, come to page B by 2. B by 2 of your, B by 2.
It does not have a
Counter filed by another senior. That is, it is a contract. It is a.
B by 2.
Give it to him, sir. She is handicapped in
I
that.
have given
Give
that.
your copy.
Copy you have given that.
Madam, in course affidavit, they have enclosed 2 documents. One addressed to IDCO by additional chief engineer who has put a signature. And here superintendent engineer, he is putting signature. And here is his signature.
He is in charge.
He
She is saying.
should.
These short term clarification they have given.
At that point of time.
A by 2, additional chief engineer. Then this B by 2, that is superintendent engineer, the same person.
At that point of time, he was superintendent engineer. Right now, at that point of time, he was superintendent engineer. Now he has been promoted to additional chief engineer.
That means he is the author of that document.
Yes, madam. He is the author of the
He
document.
is the author of the document.
Madam, let him say, I do not find any illegality in putting a date of commencement prior to an execution. There is no prohibition in the law. There is no prohibition in the law, but he must be very truthful. He must stand. If he comes, yes, it is executed on site, but the commencement date is there because it is a time-bound project, so they have to complete it within this time. There is no illegality under the law that you cannot make the commencement prior to the date of execution. He should not get that fear that the entire thing will go. It is not illegal. It is not permissible. It is permissible. But he must stand to truth. He must stand to truth. The documents are going against him.
Much by seek a passover of matters. This is revoked. Reposition have become impossible.
It has become infectious. He is saying so.
Kindly see this.
You are challenging the blacklisting order. He has said What?
There may be certain countermeasures by them.
No. What countermeasures?
Your grievance is redressed. Mercy would find.
Just be recognized.
Going on.
Yes, good.
So that
If
is,
restored, you will do that.
yes.
Yes, take this.
Uh,
Much obliged, Your Lordship.
Item 6, your junior was apprehending. So nothing. Yes,
Mr. Pawan Upadhyay is leading me in the virtual mode.
yes.
Mr. Pawan Upadhyay is leading me in appearing to virtual mode.
Why virtual mode? Not audible. You are not audible. Echo.
Lord, I'm so sorry, my lord. So many, my lord, difficulties. My apologies.
Yes.
Am I-
What is the matter?
This issue pertains to, my lord, the notification, my lord, and will draw Lord's attention on page 54.
14.19.
Page 54, Lord.
Yes, yes. Your contention is 14.99.
14.99, Lord.
Yes.
14.99, my lord, with the humble submission, 14.99 up to 2 stages. Because
That's
there
true.
is-
Yesterday, the same matter, we have dictated one order. And we have said that it should be restricted only to two integral number. It will not go beyond that. Once within the bracket you have said only 2 numbers, then you will not go beyond.
It is the EPC contract. That particular condition is not applicable. The Lordship may kindly see 2.207.
That is what I am looking at.
Your Lordship may kindly see the Roman 2. Clause 36 of Appendix so and so of the OPWD Code, Volume 2, by inclusion deleted as not applicable for this bill.
My lord, I'm
This is not a
surprised
rate
that
contract.
that applies to schedule caste, my lord. I'm so sorry, my lord, what my friend is reading out to your lordship. Please see 18th
Rather-
October
Rather,
notification.
your Lordship may kindly come to.
No. What is this clause 9, the appendix 9, clause 36 of the OPW? What is this?
This relates to individuals who are scheduled caste and scheduled tribe. On them, there is 10% advantage given to them. My friend should be fair enough in, my lord, approaching my lords and addressing this issue. Let my friend to produce this, my lord, notification first.
Lordship may kindly see.
This only applies in case of
That Roman
individual.
1, your Lordship may kindly see.
Yes.
Amendment to Appendix 9, Clause 36 of the OPWD Code, Volume 2, by inclusion. By inclusion, this is included. Then Roman 2, Clause 36 of Appendix 9 of OPWD Code, Volume 2, by inclusion deleted as not applicable for this writ. Then your Lordship may kindly come to 3.3. 3.3, page 56. This is the provision. This is the particular clause which is specific for selection of the bidder. Page 56, your Lordship may kindly.
I'm looking at it.
Yes. May I?
3.3.
3.3. Subject to the provisions of clause 2.16.1, the bidder whose bid is adjudged as responsive in terms of 3.1.6 and who quotes lowest price shall be declared as the selected bidder. Then 3.2, in the event that 2 or more bidders quote the same bid price, the authority shall identify the selected bidder by draw of lots, which shall be conducted with prior notice in presence of tie bidders who choose to attend. Now, this particular clause speaks about the bid price. Now, your Lordship may kindly come to the definition of the.
I am unable to understand that if this clause is to be deleted, then why this clause is to be incorporated? You are incorporating and then saying that it is deleted for this bit.
Because this contract is a EPS contract. If the lordship may kindly see.
No, I understand. If some particular clause you wanted to delete, then you can definitely
Should not have been incorporated.
incorporate it.
Yes. That.
Only one line should have been for this bit, the clause, the appendix or whatever, the appendix 9 clause 36 has no application.
The instructions which I have received, but so far as the petitioner's price quoted, before that I'll take your lordship to 1.5. But who is the lowest bidder? If the lordship may kindly see one.
No, maybe he was quoted 14.9905 or 07 or 5, whatever.
In the RFP, the term lowest bidder shall mean the bidder who is quoting the lowest bid price. It is not the percentage, it is the bid price.
I understood where you are heading, sir.
Yeah.
Even a 1 rupee or 2 rupee.
So far as this price is concerned, if the lordship may kindly look at the instruction that I have received.
File your affidavit within a week. Let them file an affidavit within a week.
Treasury challan was made. And now they again demanding penalty 1 lakh and same amount. Your lordship has the last order directed
Penalty.
to pass.
I have received all the documents and instructions will filing counter affidavit by tomorrow.
What about penalty? You can impose anything. Penalty,
If penalty we will also.
section rule 51. Does it?
No, Milord, it's a PWD contract
That's a
registration.
PWD.
So, Milord,
We have counter affidavit.
Oh, I just thought that.
No.
That is all.
So, Milord, the entry, Milord, they allow to participate in tender. This is 2025 my application. And they have posted your lordship last order. They have stated that my next renewal is that. Now they are imposing same amount 1,10,000. Where is the rejection, Milord? The lordship last order, they have already stated the Milord that the order of next renewal shown to 2027, your lordship. 28.
According to him, the formal order is required to be passed.
Now they are imposing penalty, Milord, because of I have made delay application, which they and the same amount 10,000 also again demanded, which is admittedly treasury challan I shown, Milord, before this honorable court that the same day it was transacted to the state authority. So they remanded for this.
Aspects, it's not only that pillar that actual aspect is pillar. The documents, the forms which he has to upload online, he has to upload it. I have got three documents.
I'll counter by 1 week. Rejoinder 3 days. Matter to appear after fortnight.
It's not on same meeting.
Yes, under
Petitioner is required to file the service agreement. Due to some medical issues, my lord, the petitioner could not come. If your lordship permit me, I can file my affidavit.
why affidavit? Who are you to file your affidavit?
Because the petitioner is medical.
So what? As a lawyer, you will file an affidavit. I do not know, sir. This is the first time I have come.
It has posted today.
This is something very unique. I could get it. You must have some authorized person. A lawyer is filing an affidavit.
Yesterday night, to see maybe.
Whatever be the reason, sir.
The parties.
This is, I think, against the Advocates Act. You can't.
It is already copies forwarded.
No, you could have done that. I have done it. Could not affirm the affidavit. Reason being this, I can understand. You have filed an affidavit. Always new things are to be learned. I'm learning it. So the affidavit of service, you are filing. Where is your clerk? A person who has affected the service, who has gone there and lost that particular, the postal article, will he not come and file an affidavit that I have gone there and lost? You will file. Where is the postal track report? Has it been served?
It is through mail, my lord. Through mail, we have served.
What mail?
Through the municipality mail ID.
When you are served,
Yesterday,
come tomorrow.
can it be there tomorrow, my lord?
Can come tomorrow, give them up at least 24 hours to react.
We are at Mr. Lalata, I requested for day after tomorrow, my lord.
Day after tomorrow, come.
God bless.
Give it back. Don't do that. Never.
Adjourn to 6th May. Item 20.
It's 33 is the demand.
There is a provision for an umpire sample to be drawn.
Rule 10, Rule 10, sub rule 5 and 7 election mechanism.
Of
OMPTS rules 2007.
OM,
OMP, Odisha, the Odisha Mineral Prevention of Theft, Smuggling and Illegal Mining and Regulation of Possession, Storage, Printing and Transport Rules
2007
2007.
rule.
Now, kindly see Rule 10, sub rule 5. Rule 5. Rule 10, sub rule 5, Roman 3.
Yes.
But Lordship sees precisely there are 3 samples.
3 samples have to be taken with randomly given a particular, the identification number. And thereafter, one will be given to you to send it for a testing, some in the laboratory, government laboratory.
Second,
One they will send, third will be kept. In the event you wanted the third to be tested, then the third sample will be sent.
third one will be the umpire sample.
Correct. Right?
Third one will be the umpire. That is in custody of police.
Now, within 3 months, time is given.
Correct. Absolutely. Now,
So-
10-7, there is a concept of surprise. Kindly see.
What?
Rule 10, sub rule 7.
Yes.
Kindly see. Both are to be read together. Rule 10, sub-rule 5, 3, rate with 7, sub-rule 7. Thanks. Before dispatch, if a surprise check takes place and there is any variation in the grade of the iron ore, then the second sample will be sent to the government laboratory. If the lessee disputes that, the umpire sample will be tested. Umpire sample which is with the lessee. The Lordship see this. And that will be
No, in presence of his lessee or the or his
so
representative.
that will be done through the umpire sample, which is with the lessee, not the report collected by the surprise squad. No. Kindly see.
What?
That's the point. Sub-rule 7 says, if during a surprise check, analysis report comes and there is a variation in the grade, then the second sample, kindly see note, that says, in case of a dispute raised by a lessee within 3 months date of analysis.
No. It is only if after the submission of an analysis report by the lessee, because you have to submit.
Yes.
And before the dispatch of the stack,
Yes.
any surprise check is there.
There.
Any significant upward deviation in the grade of the mineral is observed.
Correct.
How it can be observed? Because they have to do some kind of a testing.
Of course.
Then the mineral transportation from the concerned
That will be suspended.
leases may be suspended.
Suspended.
Then resumption of a transport may be allowed after the conclusion of the inquiry, which shall be concluded within 15 days.
Indeed.
In case of any dispute raised by the lessee within 3 months from the date of the analysis of a second part of that is the garment. The director may allow the analysis of an umpire sample at the garment laboratory in presence of the lessee or his authorized.
So,
And if he is satisfied with the genuineness of the dispute and on representation of the lessee,
Right.
that is, there are two conditions.
Yes.
It will be said if he is satisfied with the genuineness of the dispute and on the representation made by the lessee.
right. And which one is the umpire sample? Umpire sample, your Lordship will go back to rule 5, sub-rule 5.
Understood?
Yes. Yes.
The analysis result of the garment shall be final and binding.
What they have done is what they have done is that surprise check report is considered to be the umpire sample and demand is raised. That's the point.
No. Your Lordship may kindly have the instruction.
But the demand will say so. Kindly see,
Rather,
demand
on
is
their request,
No.
the umpire sample was sent to the government laboratory and it was tested in their presence. If your Lordship may kindly.
So the matter ends. Then the matter ends. If that is the fact, then there is no.
Kindly see, my lord. Kindly see the document.
Just is giving. Let them.
And moreover, against this
Yes.
demand,
Just.
Umpire sample is never taken from me. Have they collected?
no.
No.
This नहीं DA में the umpire sample का ground पर ऐसे गए थी. 39 and we had once.
Does see page 39, my lord.
No.
Lord, their instruction cannot be contrary to their own record. Kindly see page
Let
39.
them justify by way of an affidavit. You have already deposited the entire amount.
That's there.
That is there under protest. Now you have been permitted to just transport.
Just to say for clarification, just similar one line for
Page?
page 39. That instruction cannot be contrary to their own record. Kindly see page 39.
Let us see.
Just similar. Kindly see
Yes.
the last part one sentence. In view of the above, it is to inform you that umpire samples are drawn by the state level enforcement squad.
Yes.
But it can't be. How can they draw the umpire sample? The umpire sample is with the lessee in terms of sub-rule 5. Kindly see, my lord.
Not with the lessee.
Yes, with the lessee. Kindly see, my lord, sub-rule 5.
But they have seen it.
Kindly see sub-rule 5. A state SLEC cannot draw umpire sample. 10.5 pilots. Third part of the sample shall be kept as umpire sample in the custody and premises of the lessee under the lock and seal for a period of 3 months.
Correct.
So the
So it is not with the lessee, but in the custody, he is merely a custodian. It is really with them, the umpire sample.
under the
Because under seal is given, you can't.
that is
That is at the premises. You are a custodian, not the possessor.
so that is the sample to be tested,
True.
not the sample drawn by SLES. SLES have no authority to draw an umpire sample. That's the point. Kindly see page 39, what are they saying? They're completely confusing with the umpire sample issue. So their instruction cannot be contrary to their own record. 1 second. But I can show your lordship the so-called notice. Dispute raised by me. Page 35. Our reply is page 37.
Let them file their affidavit. First, let them say. Let them file their affidavits. Let them say whatever they want to say, then we'll consider it. So there is no question because the transportation has already been permitted.
Correct, Father.
The only question would be the refund of the.
Which was without prejudice to our
Yes, yes. That is what he also says that under protest, you have deposited. D'accord.
issued in this petition. And in fact, they had prepared a revision before the regional authority. The regional
That you have not said, so they have said that the matter falls within such and such period, that means you are taking a plea of
by
alternative.
way of amendment, they have challenged the order passed by the regional authority. Yes.
You just take a plea. Yes, call the next.
Item 20 adjourned to 30th June. Item 21. Pass on.
Then pass over for a day next week. Next.
Item 22.
As per the last order, plus the state was to take instructions.
But here, my lord, although I have received instruction, but they have referred to a wrong provision of law, my lord. They have referred to Rule 18, which applies to the specified minor minimums. So I have asked them to give the instruction once again. My lordship may grant me.
Because he has surrendered, he does not want to continue with this. How can you, he has paid whatever was required. Now you wanted something more.
No, my lord, his lease continues up to 2027. Even the
Not continued, 27 has not come.
But-
So his lease, the duration of the lease was up to 27.
2027
Correct. He surrenders prematurely.
prematurely.
So now what is the effect?
But
Is it permissible, not permissible? If you want to surrender, what? Something is to be done. Have they decided anything on that?
Because they have released my bank guarantee.
release of bank guarantee is totally different. My
No, everything they have done. Now what they have done? They have
It is after the release of the bank guarantee and after the payment because I surrendered.
Yes.
The subsequent year they have raised the demands.
How can that be done?
No, my lord.
Is it not an implied acceptance of a surrender of a lease?
No, my lord. Because no order. has
Then
been-
why you have released a bank guarantee?
But bank guarantee they have released. I
Bank
cannot
guarantee is only to secure that any default, if they committed, you can withdraw.
release period.
Once you have already released the bank guarantee, then there is no security which is left to you.
But-
Then what is the necessary implication?
But as on date, no order has been passed on his application for surrender. Whatever application.
But in the
he has-
meantime, you have raised the demand, then what?
But-
You made a representation against the demand.
But demand for subsequent years. Your lordship may kindly see.
Sir,
Demand is for subsequent
That
years.
is the year 2024.
Yes.
So you are saying that this surrender application is still under consideration?
No, how can he say that he has released a bank guarantee that shows him?
But still he is saying that you are making a statement that
What
still.
are you talking about?
Instruction says so.
There is a
That-
concept of an implied surrender as well.
Surrender, my lord, as per that is the only provision so far as the general minerals.
Whatever
minor-
I understand, and so far as the abandonment of the things are concerned, there are two aspects. One cannot be forced to continue. The government may lose an exchequer because he has granted a lease up to certain period. Now, there was a condition precedent that one has to put a bank guarantee. Once the authorities have released the bank guarantee, everything has been done, whatever the payments have to be done. That does it not tantamount to an implied acceptance of a surrender by him? Now you can go and make a fresh auction or a lease, whatever you want to do.
In fact, his application for surrender, whatever application he has given, that is a part of record if your lordship may kindly have.
Correct.
That he only says that the lease area is situated within 400 meters of a particular bridge. But regarding that, he has not submitted any document,
So
nothing.
then why you have released the bank guarantee? I'm asking you, which is one of the condition precedent in the rules itself. You have to release bank guarantee only after the expiration of the period. Now it is a case of a sooner determination.
Your lordship may direct that let the authorities take a decision on his surrender application if it is pending. Because it is pending, that there is no dispute that any order has been passed on his surrender application. Let the
But it
authorities.
appears that he has impliedly, whatever, the no reason order, but the conduct. Then we'll be recording this conduct. Then recording this conduct. That you have released a bank guarantee that amounts to a implied surrender.
Let me file an affidavit.
Then don't insist for what they are doing.
That is only, nothing has been done, only demand has been paid. Because if he is not, meaning,
Well, the demand is that,
Uh,
12 lakh.
The petitioner has challenged the
Three.
GST article. GST articles.
yes. 24. 24. Yes, who is appearing? 24,
Yes, sir.
25, who is appearing? 26,
27.
7 signing.
when the Supreme Court has fixed the date.
Item 28.
20 appeals. Petitioner
28. How many matters?
That's the situation.
Why it is mentioned?
3 members.
Why it is mentioned, sir?
there were 3 appeals.
Why it is mentioned? Why it is mentioned? It has come up by mentioning. Why?
All the persons have retired. They are now deprived of getting the pensions.
They are
They are retired. Whensoever
they are deprived or not deprived?
they are deprived. This
No,
benefit
they are not deprived. So that's why I
They are all senior citizens, they are deprived of pensional benefits.
yes. So what the single judge has done?
In fact,
Let Mr. Rodney do it. You are the first matter. Do it.
but
Where is the order of the single judge?
page 181.
One.
Page 100, it starts from page 166. 66. This is regarding career advancement schemes. But as per the government resolution, which is adopted by
Just 1 minute.
right. So, what else? What is the 166?
So according to the learned single judge,
The Honorable Single
you are governed by the Odisha Education Service College Branch Recruitment Rules of 1990.
But the Honorable Single
And the Education, Odisha Education Service College Branch Rule, Recruitment Rules came in 2020, which with effect from 18-2, and you retired prior thereto. So even the judgment which is rendered, according to the single bench, rendered in case of Dr. Dhiren,
76%.
Dhiren, 76%.
Something different, but
Dhiren, that is not extended to you because you constitute a separate class of a person, separate class of a person. And if the subsequent rules came after you attained superannuation, then you cannot claim that right retrospectively. And therefore, the court has said that you are not entitled.
But if the Lordship will see, the Honorable Single Judge has
This is what
completely
is. Huh?
failed to consider effect of government
No,
inclusion.
cash, you say that professor, he says, what is the purpose of the cash?
Sure, sir.
Career advancement scheme.
Sir, the career advancement scheme.
When it came.
That was a concept which was originated from the UGC, University Grant Committee.
I know, yes.
Now the state government has accepted that UGC norms.
When?
By virtue, that is exactly the point, sir.
31.
So now entire our case is,
I'm so
so the entire case of ours is that 21 rule, the statutory rule, which came into force after our retirement, that is in respect of promotion. And that has nothing to do with the career advancement. The career advancement was governed under that resolution that is at page 9, at page 64, annexure 6. Let's look to this. The entire case is like this. And the person, those who have been.
So you wanted that you do not want that you should be promoted to the post of promotion. You just simply wanted that the career advancement scheme, whatever the benefit which is provided, mandatory benefit you give me, I do not want to
Yes.
put a placard in front of my house as a retired professor.
What is the point?
That is the point. That is the point. And this judgment, the interim judgment passed by the Honorable Single Judge. And in fact, this is offshoot of.
So Rautre did not react, that's why.
And me also, I was not reacting. I know what will be the trump card for your Lordship.
That is the entire case, sir.
Yes, who is for the other side? So it's a small question. Can we fix any other day for this? You come ready. Because the court has simply gone on that basis that once there is a separate recruitment process which is provided for recruitment, the court has also said that it's not a promotional post at that point of time. So in that event, you can't take an advantage. But what he says is so far as the career advancement scheme is concerned, it's a monetary benefit which is given, not putting any person into a substantive post. It is not a case of a promotion. Nor we should be designated as a professor, but we should get a monetary benefit at par with the professor. That is what, according to the cash. That has not been gone into by the signal. So you come ready. It has not been gone. Come ready.
4.2.
That is, yes, but in a different manner. When? Tell me.
Any date after 2.
Whatever, when you can get yourself ready. It's a very, very small issue.
Very small. Any date after 2 weeks is nothing.
Then it goes out after vacation, you essentially pray for.
Fix a date, give me a date.
Maybe 24th after you please.
24th? Do it.
24th.
Can it will be a specially fixed matter at 24.
2.
Yes.
2 o'clock
Can we,
in the morning.
can we discuss?
Yes, morning 8 10.
Sorry to not get your Lordship. I'm so sorry.
Yes. 24th is a?
EIL tenders.
Then this matter is? Then 22nd, why not?
Yes, absolutely.
22nd. as a specific. After hearing the respective counsels, we feel
Item 29.
that's the very small question. Yes. Where is the impugned order?
Annexure 5 page 194 to 2204.
How it has gone to the single bench because it relates to a tender matter?
And
How it has gone to a single bench, it relates to a tender matter?
it will be Aadhaar for granting of Aadhaar.
What?
That Aadhaar, that for distribution of Aadhaar in the
Ahar scheme.
Aadhaar.
Aadhaar.
Khaiba jo
No, I understand. Ahar, I know the meaning of ahar. That's the food. I understand. But it was in relation to a tender. Tender was invited for supply.
it is a SSG group. So SSG group
But the-
that has been tackled by the
Previous self-help group, I understand, but it relates to a tender matter. So how can it go to single bench? Yeah. How it will go?
So the
The expression of interest, that's a tender matter.
category ଯୋଉଟା ଦେଇଥାଉ ସେଟା single bench ର category ଦେଇଥିବେ while furnishing if you would have given that
Item 29 এটা 34,430/25 Rate petition notice. Petition টা কার
So you participated and thereafter you are challenging the expression of interest.
Manual of the fact remains there.
Sorry, there is a judgment that goes that once you participated, you cannot then turn around and say that this is wrong, this is.
No, madam. By changing the modalities and norms of the interview, I challenge that. I have not challenged the guideline below. As per the guideline,
Have they not indicated that what modalities they will adopt in the interview, in the tender? They must have indicated.
that is not been indicated. That's why I filed the case before single online single.
paragraph 8 it's very clear. Okay.
No, paragraph 8 of the judgment, it has been stated that since you have participated in that,
No. Not only that, you know the criteria for accepting the criteria. You know.
No, I know
While
the criteria.
participating,
My lord,
you knew
my lord,
the conditions.
my lord. But I admit that as per the guideline, they should give the appointment.
No.
But
That itself is.
by changing the modalities of the.
No, at the time of participation or interview,
My lord.
you knew this condition?
Yes, my lord.
Ah.
But my lord, they have
What
added
is?
other things by superseding that guideline. That's why I filed the case, my lord. My lord, they stated.
No, before that you knew
My lord,
that
that is not known
for
to.
participation, you knew that this condition is contradicting any guideline?
No, my lord. My lord,
You didn't.
after filing of the case, the opposite party gave the counter. In that counter, they supplied that document which was come to our knowledge. That's why my kindly see page 143. 143. They defer opening up for the tender another date. But in the meantime, without giving any notice to public, without giving anything, they have taken a decision. And as per that decision, they have passed the order. And accordingly, the opposite party 6 was giving the expression of that distribution of Ahad. Yes, I find. For that, there is judgment, Miller. I have cited that the Madhumita Ras and another Miller, 2500 CLT 465. During the selection process, nothing can be changed, Miller. Which is a violation of the.
What is the procedure and what is the violation that has come? You are not in a position to show us.
No,
Nothing is there.
Yes, I have given my every.
Sorry, you have not given it. 28. We have given, but you are not unable. But you are unable to pinpoint the same.
Page 42, my kind.
Yes.
Page 42.
Is valid to 20.
42.
Yes, 2810. It is 2410.
In page 42.
Yes.
Towards last. The MNC Murder Swing Gosti having experience in similar kind of activities may be given preference. It has been stated in the guideline, but they did not give anything more. Rather,
What?
The MNC having experience in similar kind of activities may be given preference. We have given 5 years experience, but we have not given any chance.
No, nothing. Yes.
Thereafter, in this guideline,
Just
wherever it has been stated that a new SHG group will be given interest to the work.
why not? So it will be it will be only a one choice. Only you have to be given. No other person can come.
No, I have no objection.
No.
If they would have been given this thing, we would not have been applied.
In you,
And whereas in the expression, it is there.
what they have done.
The municipality, they have taken one decision on 10/9/2025. 10/9/2025.
So 10/9 is before the last date of submission.
Permitted to submit something.
Where is that? 10/9.
That is it, 142, page 142. The municipality, they have taken decision at 142, page, that is 10/9/2025, stating therein that
142.
142.
142 is this page.
That is dated. But they have taken the decision of 139. 139.
How? I do not know, sir.
139, 139.
I am incompetent and helpless. I can't read 139.
Sorry, my lord, I will permitted to submit the translated copy, my lord. It will come tomorrow, I will give that.
Who's for the other side?
The total municipal corporation has to be this fill this.
Who normally appears?
Pranamanti.
Devasis.
Or Devashish Industries.
Yes. And one copy was for. No, who will one.
Serve him a copy. Must put it in the next week.
11th May.
Service record. Service of the copy of Mr. Wolf.
Devashish. Who usually approves for?
Call the next.
Item 30.
After vacation.
Item 31.
Is it maintainable? Is it maintainable, this appeal?
Two judgment, I am submitting one judgment.
What?
You are for respondents. Sir, you are for respondents.
What?
My learned friend, what is maintainability?
Huh.
My learned friend argued one matter before a division bench. And the honorable division bench asked my learned friend to address the court whether it is maintainable or not. And my learned friend has withdrawn it. I am submitting the copy.
Stupel cannot operate against him.
No. There the judgment is, this is not a,
Stupel against
it is not appellable.
will not operate against him.
Let him argue on the very.
I have
No estoppel against the lawyer.
No, I just got to the notice of the lordship.
That's
in view
fine.
of-
No, sir, because it is a first appeal, whether the mandamus appeal dies.
the right question to me. If at all it's an order under Article 227 or
If it is 227, no appeal lies.
no appeal. But if the order arises out of a tribunal under the election dispute,
Then also 226 does not have.
I have two judgments here.
No, 226 cannot.
Kindly, sir, I have two judgments. People also could consider this.
Suryadev, Radhesham, these are the two judgments which has come, which can't be. Distinction between 226 and 227.
Umaji Kesrao, Lordship C 86 Supreme Court, then Joginder Singh Ji 2015 Supreme
I
Court.
do not know what is the composition of the bench.
Their lordships are probably
What is the composition of the bench?
bench, I don't know.
Shivaji?
Umaji Kesrao 86 Supreme Court.
Yes. What is the composition of the bench?
But these are 2015.
Yes, our whole High Court judgments, kindly similar. Lordship C is 2016 SC line Odisha 296 para 17 my lords mechanics. With regard to maintenance.
Which judgment you are citing?
Lord, I am citing this case of Saraswati Patra.
Page,
Sorry, Saraswati Patra versus
paragraph.
paragraph 17.
Here, Mr. Samal appeared.
Yes. So I don't claim a stupid against him.
No, that's the privilege of a
Yes,
council.
that
It's
is
not
why
difficult
I always say we
to argue both sides.
we can change our colors.
In one of the cases, Mr. Samal, another is Mr. Gautam Mishra.
Mr. was speaking here, right?
No, there are two aspects. If it is a court, then the judge exercising the jurisdiction would be construed to have been exercising jurisdiction not in persona designata, but as a court. If it is a court, 226 bar. 227 can be maintained. Then further appeal does not lie. If it is a persona designata, then in that event, one has to consider whether such an order is susceptible to be challenged by way of a writ jurisdiction, provided the appeal remedy is not given in the act itself. If it is a tribunal, 226 has its jurisdiction, so power of superintendence both against the court and the tribunal. Tribunal may be under Article 323A or 323B, both.
That period.
And of the Constitution.
Okay.
There may be a statutory tribunal also by virtue of a special enactment.
Yes, yes.
I know those would also come within the purview of a tribunal.
That's a very larger issue, Milord. Your Lordship will also decide that in this writ appeal, along with those issues. And one more.
I have a doubts. Then I have to refer the matter to a larger bench.
That's the point. But kindly see 2000.
I have if it is a division bench judgment,
both are
is a coordinate bench, so I can't unless I find a Supreme Court judgment directly on the point. Contrary to this.
But kindly see also 2010 SCC on that.
No, I understand. Radhesham did not accept the Suryadev Rai's particular notion. And as said, and Radhesham is a three-judge bench decision.
Radhesham is considered here, my lord.
Three-judge bench.
Well, 1 second, Mr. Sam. One second. Kindly see 2010 SCC online page 86, my lord. Para 4 and 5.
Odisha.
Yes, my lord. Odisha. It's also division bench. Then I'll leave it to your Lordship, whatever your Lordship will say. Umaji Kesrao is considered here, para 5, 86 Supreme Court.
Because why I'm saying is, I do not know. These judgments are here. I'm bound by. But I have an experience of another. There, what has happened, the similar kind of a situation that arose.
One the small query from my side to your Lordship. I want to know one thing. What is the nomenclature of MAT in Calcutta High Court? MAT is
mandamus appeal.
It's a mandamus
appeal. Clause 15 appeal of the letters patent.
T is there.
MAT, mandamus appeal tender number.
Mandamus appeal
tender number.
Right, I am sorry. I was little, why this?
He connotes a tender number, which you are here, the diary number you are giving, there the tender number is given. And thereafter, once all things are removed, then it is given a FA or FMA or MA, mandamus appeal.
Mandamus appeal.
Not a T goes.
As we are seeing here, 226 is the original jurisdiction of our High Court here. So, is that an appellate jurisdiction? No.
Is a both. Appellate and the original both.
227.
226 is both in the appellate jurisdiction and the original jurisdiction.
So that is why it is a MA.
MAT initially registered, converted into MA.
Mandamus appeal. Then what will be the writ appeal in our here? Like
which one? No, that is the writ appeal.
Oh, that is the writ appeal.
Clause 15.
Then what is the
of the latest patent?
What is the
I think clause 10 here or that.
Clause 10.
Clause 15 of the original latest patent of 1862. They are governed by that latest patent.
So division bench matters.
So division bench patent.
The original one?
Original will lie to a single bench.
The nomenclature of original jurisdiction.
Original WP.
WP. Like ours also.
WP.
But one difference is there. In Calcutta, the 227 is nomenclature as revision. CO.
Civil orders. But it is within the revisional jurisdiction.
Yes.
It is never considered to be a writ jurisdiction.
But here,
writ is never. So writ is 227.
227 is never regarded as the writ. It is always regarded as the revisional jurisdiction.
It was filed in our High Court writ applications, but subsequent after the Supreme Court judgment, the nomenclature has changed. It has become CM.
So there, here it is a civil miscellaneous petition. There it is initially civil rules. Then it is now civil order, CO. Since 1990 is a civil order. What I'm saying is that there is a special bench judgment there. There is a West Bengal Land Reforms Act, 1955 or 6. There, a provision relating to a preemption is provided. Suppose an agricultural land is owned by somebody. If he sell it out to a third party, stranger, then 3 categories of the persons have a preemptive right to buy. Object is avoid the fragmentation and embrace the consolidation, which is also here. Same principles. Is the Agrarian Reforms Act, so naturally same principles come. Same principles comes. So there may be several co-sharers of the entire plot inherited. One of the co-sharer, if he sells, then the right is first given to a Bargadar, means Bhagchas officer, who does the cultivation on a shared basis. What is the terminology? I do not know here. Is Bhagchas. So we call it a Bargadar. Bargadar. So that right is given. He can apply to the before whom? He can apply before the Munsif. The word which is used is a Munsif. And deposit the entire sale consideration amount with 10% more and say, now sell it to me. So the word Munsif which was used there. Then the question that arose was whether this Munsif, he is really acting in a persona designator or as a court. Then the confusion was there. There were 2 divergent views of the 2 division benches. In Pashupati Adhikari's case, then ultimately the larger bench, special bench, held no, Munsif is not really discharging his duties in a persona designator, but has a trapping of a court. The matter went to the Supreme Court. It was admitted at one point of time, but that judgment is still operating. That designation, the Munsif or a civil judge, does it mean a persona designator or a trapping of a court? Similar analogy which I am drawing. If it does not have a persona designator, trapping of a court, then Article 227, no appeal lies.
That is the full judgment even of this one.
Mr. Sasma must be agreeing with me.
Because they give back.
There is a
But I
of this one report. You know,
So you can consult that Pashupati Adhikari's judgment of the Calcutta, where I think Justice
Pullman decided on the same terms that has been reported in 2008, 2009,
Justice
Odisha page
probably
43.
Mathur. Later on, he was elevated in the Supreme Court. Probably. Justice Mathur or Justice Arun Mishra, I don't know.
Chief Justice of
Several judgments of the Supreme Court was considered there, and ultimately it was held. It has a trapping of a court. Munsif does not really discharge functions and duties in that sense.
But there are 2 judgments here. They say that the trapping of a court is not there. That pure tribunal.
So not designator.
Yes. It is by Honorable Justice A.K. Mathur.
A.K. Mathur. I was Pashupati Adhikari. Or Pashupati what? Adhikari, I believe.
2003, Volume 2, Calcutta Law Times, page 538. Pashupati Adhikari versus Pradyot Kumar.
There this point arose. Persona designator or a trapping of a court. Let us hear. It's an interesting point I want to hear. Give a date. Come ready. Which judgment you are having in your armory?
Yes, yes,
What judgment?
This is the full bench judgment of this honorable court. For
Okay,
one paragraph,
It that do not deal with the
Last page.
designata issue or a personal
Last page,
designata
paragraph 3.
or a special statute.
There is judgment in
This is
personal
also taken
designata.
care
That's
of.
the general principle.
This
This
is
is how
also
the
taken
general
care
principle
of.
will that doesn't deal with this kind of.
No, that is,
That is settled.
Mr. Samal, there is no quarrel in my mind also.
Right.
If it is 227, no appeal. No doubt about it. If it is 226, definitely. Second question, whether these kind of a situation, the writ petition is maintainable.
Yes.
226 not maintainable.
Not maintenance.
Then
What I'm saying
the writ petition also goes.
has to.
That has been taken care. That has
No,
been taken care.
I find it is an FAO, first appeal. That's why I am putting a question. Because second appeal only lies under section 100 of this CPC.
100 will be a bar. 100 will be a
If
bar.
it is nomenclature under 226 or 227, it has to be gone into what is the tenor of the order. That is the judgment. That is Sabinath has taken care of. Even if someone also mentioned, it is under article 226 or 227. The judge has to see
Let's
whether
agree
it is
on
an
the
order under 227.
Let's
What
agree
is
on
the
the
scope of
points.
power?
Let's address your lordship on the points. It's pure question of law.
Any
Your
date
lordship,
given to your lordship.
any short date, because the
Short
dates
date,
will
yes.
things will become academic thereafter. Any short date.
Next Monday.
Next Monday, I don't know. Next Monday. I'm subject to my lord's convenience.
No. Next month, we are convenient in all days.
Right?
And particularly when a pure question of law, some kind of an energy level that increases. It's Monday.
Item 31 adjourned to 11th May. Item 32.
Please consider that judgment of Pashupati Adhikari also, both of you.
Go through that.
Go through
I'm
that.
taking note. I'll go through. You will decide the status quo.
Yes.
My learned friend is requesting for status quo. I'm saying don't press upon now because maintainability issue is there.
Yes. Where is the judgment of the Supreme Court? Where is the judgment of the Supreme Court? You said that once the contempt application is disposed of, the writ does not lie.
Para 17.
What are you talking about? Sir, the question is not that. The question is if the contempt application is disposed of or a drop, whether the writ petition for the implementation of the order is maintainable. The learned single judge has said, no, it is not maintainable.
16 madam.
No, this is also not an answer to the point. The point is different, sir.
It is fresh.
Whether the miscellaneous application in the disposed of matter is maintainable. On that ground, it has been said. Here you have filed a fresh writ petition. Your contempt was dropped. Whether it is maintainable,
It creates a press cause of action.
not. Don't you come with a Supreme Court judgment?
I apologize if I have.
It is a court who has to find out a judgment for you. That's the only point. On that ground, it has been dismissed. So we do not find a judgment. There is a judgment. I have written, I am unable to find out. Anyhow, you have to find out a judgment. I am unable to find out right now, but you'll have to find out a judgment. There is a judgment which says that yes, Supreme Court judgment is there. Yes, call the next matter, I believe. If I get it, I will definitely give it to you, but I'll have to find out.
Your option is not going to be given and find the judgment.
The judgment is of disposal of main litigation, whether any clarification or any modification in the garb of IE.
Those are different kind of judgments which you are saying.
We are not
citing.
saying that.
The single bench has dismissed because your contempt application got dismissed. Then in that event, it says that the writ petition is not maintainable. Please consider that point. The writ petition is maintainable. Find out a judgment. Directly, there also the writ petition, the contempt was dismissed. That judgment. I know only one judgment of the Supreme Court. Find out. Yes, next week.
Adjourn to 11th May, item 33.
Petitioner's father, a member of the minority community, was granted certain lands, forest lands in Malka.
Why the single bench has not?
Well, the single bench, on an erroneous reading of the statute, has held in para 13, if your lordship sees, he says that these are Gramya jungle lands which cannot be settled. Well, that is directly
Admitted position.
He says in para 13, Gramya jungle, and these lands cannot be settled. Now, your lordship sees these act.
And you are not a member of the scheduled tribe.
This is a Muslim minority community. You are,
You are OBC, not ST. There is no concept of ST there.
Judgments both ways, but recently I came across a judgment which has held that Muslims do not belong to scheduled caste group, right? But
Never. There is no concept.
But there are certain judgments.
OBC may be a factor which is now pending before the Supreme Court.
But here the requirement is traditional forest dweller. What it means is member or community which has for at least 3 generations prior to 13th December 2005 primarily resided in and who depend on the forest or forest lands for bona fide livelihood needs. This is the definition. So I need not be a scheduled caste, I need not be a scheduled tribe. I have to be a traditional forest dweller, which I am since 1920.
Who is for the other side?
The state will.
Para 17 of the judgment itself speaks that the enforcement steps are initiated against them and eviction order was passed.
What he contends is his right is crystallized even prior to 2005. That is the cutoff date to claim his dwellers, under the Forest Dwellers Act. A cutoff date is there.
Yes.
He has been issued with ROR much prior to that also. That is why he is claiming his right under the Forest Dwellers.
That is true. But once the eviction order has been passed and that has not been challenged.
Why you are not challenging the eviction?
What happened was there was a proceeding under the Forest Dwellers Act. The order was passed there, and I was called upon to respond by a particular date. I filed my replies. That was never considered. Now, my lords, in the counter affidavit for the first time, they come up and say that we have started a OPLE proceeding that's under the Land Encroachment Act and we have passed orders of eviction.
So
My lord,
have they not given you a notice?
Never. No.
So did you not, will you not challenge that also?
Well, I have challenged that. I have challenged that in the writ petition that this order which they have passed is not under the Forest Dwellers Act, which was sub judice before the authorities.
No, whatever is there, but
You're right.
independently you have to challenge that order.
I have challenged that.
Where is the writ petition? Show us the prayer of the writ petition.
Yes, sir. Thank you.
In the prayer of the writ petition, it is only 2006 Act.
2006 Act. Yes, my lord.
Have you sought for a declaration that this order is non-est in view of this, whatever?
Under
You have to
PLA,
Yes, my lord. I have sought for quashing of the proceeding under Annexure 2 and 3 because that is the proceeding
No.
which they are referring to as a Annexure 3.
in the writ petition, no.
In the writ petition. In the writ petition, there are two proceedings.
Petition is 14868.
Repeat some 14868.
14868.
The prayer is
Prayer is, if your lordship sees the first prayer, appropriate writ be issued calling upon the opposite party to show cause as to why the application of the petitioner next to one shall not be accepted and he be conferred with rights under the 2006 Act. If the opposite parties fail to show cause, so insufficient cause, the writ may be allowed by quashing the proceedings under Annexure 2 and 3 respectively and settle the forest right in favor of the petitioner under Annexure 2. So,
Very innovative way of couching the relief. Relief should be very specific, lucid, precise, and this is the way. It is dependent upon a showing cause.
but
If they fail to show cause, then it will go. It's what kind of a prayer?
not very happily couched, but
That is what I'm saying is the way of drafting.
that is
Is what do you say? Then he has challenged both. If he has challenged both, then on the ground of natural justice also he was not given a notice, or he was not served with the notice, not given a notice, I would say. Served with the notice. He was not served with the order.
very interesting column. ଆକ୍ରମଣ କରାଯାଇଥିବା ଜମିର ପରିମାଣ.
Akrumana? Attack. Akrumana means attack.
ଆକ୍ରମଣ ହୋଇଥିବା ଜମିର ବିବରଣୀ,
Acha.
ଆକ୍ରମଣ କରାଯାଇଥିବା ଜମିର ପରିମାଣ.
and this order, the proceeding under 2006
So that is the proceeding.
is being conducted, and what is being done is an order under the OPLE Act is being passed. The proceeding itself gets vitiated in the process. Without dealing with my rights, which have crystallized by the time these proceedings were
You should
initiated.
have raised this point in that OPLE proceedings.
Had I been, but I was confronted with this order and a penalty straightway. That is why I came up before your lordship to invoking the extraordinary jurisdiction.
The entire case is the notice was served to him. Even after the order was passed, he has never challenged the order by filing appeal.
But this order is challenged in the writ.
Sir, to file an appeal.
Sir, one thing I could not understand from the form J in the writ petition. The ଆକ୍ରମଣ ହୋଇଥିବା ଜମିର ବିବରଣୀ ହେଉଛି ଜଙ୍ଗଲ, right? Then କି ପ୍ରକାର ଦଖଲ? Water tank.
Water tank.
Nature of the position is water tank.
That is not, and fine is 5,000 rupees for eviction.
That record is not with me. Let me take instruction.
No, it is there on record.
That is forming part of Annex 3 of your notice.
Protect from eviction and invite him to work. When after vacation?
After return or fiction will take.
Date for hearing. Interim order for eviction, from eviction.
Question of possession, actually, I don't have an instruction whether he is in possession or not.
We simply say that if he is not evicted now, then he shall not be evicted. That's all.
Okay.
Status quo, I am totally against.
No.
Don't worry.
Be confused always.
My lord, one more submission, my lord. By the impugned order, 3 writ petitions were disposed of 3 different brothers. My lord, the other 2 writ petitions are not being listed because of a defect. Because an order has been passed impleading a party, but they are it is not reflected in the certified copy of the order. Because of that,
Let that be listed again.
I'm giving those 2 now.
Yes, yeah. This will be listed. It will be only in this. He has called the next.
Item to 22nd June, item 34. May I please do
Where is the impugned order?
Impugned order, my lord pleases to appreciate the facts. That's why I want to first
Page.
my lord. Impugned order pays it at transfer order is a challenge, my lord.
No.
And it is in Annexure 5, my lord.
Annexure 5, page 77.
77. 77A. Acha, this 77. Yes. Yes. I have these following solutions.
3 medical documents I need to submit. Yes, madam. First one is turning page 57, madam. The petitioner is 40% disabled. That's true. He is a psychiatric patient. And the period for disability certificate given for 2 years. That is up to January 2027. My humble submission is till that date he is allowed to return here at Group Center, Bhubaneswar.
If you are a psychiatrist patient, then how you will discharge your
Yes,
patients?
that's without arms. They are composite hospital at Hyderabad.
No, I'm asking how you will be discharging.
They are allowing my
So
lord.
you should be removed from the service also.
It is there. It is they will do. That's why, my lord, my humble submission
If you
is
are medically, if you are not mentally alert, then you should be removed.
Aims as well as their composite hospital at Hyderabad, they have certified without firearms, he will be given duty. And now they are transferring me to Assam, Bodo Kuki area, my lord. Without firearms,
No.
the GT will go there.
You are going to Guwahati. What are you talking about? You are going to Guwahati. That's a the developed city. There, the AIMS is also there.
Yes.
So that's why, my lord,
That he said that I will extend all the facilities which is available.
even my lord, I want to place the latest AIMS, my lord.
Solicitor is very fair enough or very compassionate enough to say, if you approach the authority, the said authority is directed to take a sympathetic view.
Yes, my lord. My humble submission is
Still it is open.
his medical certificate was not considered. Only the latest medical certificate I want to place, my lord.
Then you invite some trouble for yourself.
Yeah. 83, my lord.
That option-
83, my lord.
That option also will, you will.
Without firearms, he will go to there, my lord. And my lord, what is the distance, my lord? I want to place. It is 65 kilometers away without family members, my lord.
Then inside the CRPF also we have a 100-bed hospital in there in Howard.
Composite Hospital. Apart from this,
Is a question of psychiatrists to be placed there.
My lord,
You may have a hospital but may not have a psychiatrist there. Every hospital does not have.
but Guwahati, everything is available.
So he's within the city of Guwahati.
Yes,
Guwahati.
good.
So very
And we have a 100-bed hospital, all facilities, everything is available. That's why I've considered the same and put it there.
and he's here since last 4.5 years, continuously on that ground.
Leave from this place now.
On that ground, he is there since last 4.5 years. Extension was also granted on this ground.
the same ground they have given extension, my lord.
It's true. How long you will continue and how long you will continue to do it?
Yeah,
You are in a transferable job. Transfer is an incident of service.
But my lord, in other matters, he made a representation. Oh, they're
So
non-speaking.
you were earlier considered, you were given a chance, you are here since last 4.5 years or more.
It is only for 7-8 months, my lord. Because he
By
admitted.
the court, you know the decision of the Supreme Court in a transfer matter.
My lord, I know, but my lord, it has
Why
not
the court will interfere in a
medical
transfer matter?
document has not been considered.
These have been considered, everything has been considered.
I just want to submit their report, my lord. That's the annexure running
Hey, what is this?
59, my lord. Running page 59.
What?
Yes.
Two lawyers, they were standing for what?
Yeah.
Oh, it's a defect of us. No, better.
3 medical documents only I want to place, my lord. They have allowed, my lord, 40% disability with 40% disability.
I have a very strong reservation for transfer matters so far as the interference under Article 226 is
My
concerned.
lord, even my lord, one humble submission.
There is any policy, there is any rule relating to transfer?
Yes, in 2020, the government of India has framed a rule. They have given option, but maximum period retaining is 3 years. The person who is continuing who is after 3 years you are transferred, they have submitted application, it was considered, we have considered the medical records also. After that, again he is coming and filing a case, this, I have a right to continue there.
No, I am not saying, my lord, my right, my lord.
Because
I am only praying, my lord.
only only
He is under what organization?
CRPF,
yeah.
So,
paramilitary force.
That's why I
It is a
say
duty, my lord.
we have a 100% hospital in
what did he?
General duty, my lord.
Yes. So where is the difficulty?
My lord, it is the.
Is
it
not
certificate
given an
taken.
arm, is not having an arm,
That is
not an arm duty.
Yes, my lord, we have a lot of works there. So this concerned commanding officer, he will definitely consider about all these things. He's not joining any getting the benefits. He is fighting the cases.
When he has been
Yes, already
given an order of transfer?
9/4/2020, he has already been relieved. He didn't join. Unless he will not join, we will not extend any cooperation to them. He has been transferred as passed on 22/12/2025.
That was the order, but given effect on 15th April, my lord. That is not submitting. And also for this election,
There is
They are
a lot of applications are filing before the honorable single judge against the transfer.
they are not considered, my lord. That is not my submission. Because and even, my lord, they have.
Is a general transfer.
Yes,
Yes,
some of them
someone can transfer, my lord. I humbly saying it is their document. They have issued me disability certificate, and that is temporary. That is up to 17/1/2027. But a person with a 40% psychiatric disability will go there, and without family, my lord, he himself will go to.
Take your family. Why you are not?
That is not allowed there, my lord.
Why it is not allowed?
Let them take instruction. I will take my family, my lord.
My lord,
That way we consider.
the single judge
Let him take instruction.
specifically said that will extend the responsibility to paragraph 5. I have mentioned.
No, I have seen that.
Yes, my lord.
So-
my family may be allowed, my lord.
Let them go and submit the application, give the command, but whatever action taken, that unit will take care of, not the Bhubaneswar unit. So he did joining and the court sort
So in the
of.
Bhubaneswar unit, he is allowed a family to live.
Yes.
So there also, I think the same.
Same work.
That's why my lord.
Maybe one thing, maybe inside the here is a lot of quarters. There, what is the context? I can't say. A lot of people are residing with their families. Their families are there.
Battalion, they are allowed to take their family, my lord. If not a DAG is submitting, they are allowed families there. That is my whole submission. Family is not allowed. And categorically, their hospital said he should live with his family, my lord. It is only temporary, my lord. Their hospital said it is composite hospital, Hyderabad said it is 40% disability. They have issued the certificate.
Now I got the instruction that we have a 100-bed composite hospital in Guwahati and we will extend all set of.
And he has been transferred to Kanpur, that is for 65 kilometers away, my lord.
Yes.
65 kilometers, let them file a counter.
Need to be what counter is, my lord? What is the record of the work already?
That is my specific submission, my lord. It is 65 kilometers away, the battalion is. And in my representation has been disposed of by non-speaking order. In similar matters, the transfer
There was a direction passed that till 15th of April he will go. He has not joined.
No, he didn't just.
Despite the order. Then take steps, whatever. We are not going to stay any order. We are not going to extend any interim order. It is up to you. It's a disciplined organization.
Yes.
If he has not joined, then it is up to you to take a decision. Let them take a decision.
At least his
No interim orders, no interim order protecting this. Maybe. But you go and join and then come, we will consider it. But if you don't join, no, sorry, we can't.
Family facilities are not there.
Sorry, it's not that you are not discharging duties. If you are incapable to discharge any duties, then the rules are there that you cannot remain in service also.
That is why two-year
No, sir.
temporary period of
No, sir.
certificate has been given, my lord.
No, sir.
He may recover. Their expert doctor as well as AIMS doctor had said so. And my lord, one last submission, my lord. Running page 83, my lord.
Yes.
This is a certificate given by AIMS, my lord. That is dated 2/4/2026. To whomso it may concern, in continuation to our previous suggestions, this is to state that patient has been continuously suffering from hypochondriacal disorder, depression, paranoia.
2-degree depression only.
Hello?
2-degree depression. Are you seeing page 46?
Completing my family with all facts. Psychiatric illness patient's current psychological status requires close family support and continuous
That was when?
Hello?
What is the date?
Date is, my lord, 2/4/2026, my lord. That's what I am submitting, my lord. It's AIMS report.
Page?
Page, my lord, it is
82.
82, my lord.
This is outpatient card. We advise
He was treated there.
Let us see. Yes.
82, my lord. And my lord, if my lord, I want.
Okay. Take yourself. Take him to the hospital and get him tested.
Yes, madam.
give a report.
Because the running page 57, doctors also recommended.
The petitioner relies upon
The submission till date the petitioner should not disturb my law
no.
or compare.
No, sir. From 15th April, you are not disturbed.
Yes, madam. His old
Sorry, we got-
description to be
No,
constitutional.
sir. No, sir.
With the same, madam.
No, sir. No, sir.
Because the CA
Under no circumstances.
whole documents.
No, sir. Definitely not. You have not joined after 15th April. Next.
Item 34 addend to 11th May. Item 35.
Make the jurors. Here,
How many matters are there? 38. No. Is up to 38 this category. Yes. Huh? 36 is the last. Which matter is called? 35. Okay. Yes.
make the jurors. And this petitioner to the lordship, they are working as sweeper from messengers in
What is, where is the impugned order?
And the
Or the-
impugned order is at page 188. My grievance is this. My if a
Just 1 minute, let me.
Page 193 over. Starts from page 190.
relevant page 188.
Just one. Notices to the back. You have to issue a notice to the. I understand. You say that your wages has to be paid in the minimum wages, but the single bench has said that since you have made a representation, let every branch will consider and.
That is not the only point. The writ petition was entertained, notice was issued, interim order was passed, counter-objective direction was issued. It took time.
Anyhow, you have to serve a notice on the bank.
That was the interim protection.
What interim protection?
No.
Wages is required. You will get the money from the backdate.
There was no coercive action.
No.
Where we moved the writ petition, they threatened to terminate.
If they threaten, come. If they threaten, just give it.
That may be a problem, my lord.
No, there will not be a problem in the last week before vacation.
18th May.
We're filing the notice by tomorrow, my lord, so that it can be.
Item 36.
Obliged.
President appellants and President appellant and three others. They were deputed to the central bank.
Where is the improved order?
That is annexure 1. But you will find it.
Page?
It starts from page 18.
Page?
Page 18, madam.
15.
It's a very short and interesting issue. The respondents have preferred an appeal.
Just one.
How can time barred appeal? Their appeal is time barred.
Notice.
On interim
18th.
So they have concerned by deputation, then take action. Status charge they at least. That will be directly produced.
You are already working under the urban.
So in the borrowing bank, but now impugned order, Lakshmi kindly see the stringent action they will take against us. To that extent, kindly protect us.
Be passed. This cannot be.
Kindly protect us to that extent. To that extent.
There should be a protection.
No coercive action at least be taken.
You have been repatriated to your.
Our deputation is cancelled. We are called back to the original bank.
Correct. That's an urban, not in Cuttack Cooperative.
Not in Cuttack. But we are getting all benefits, salary, everything from the central Cuttack Cooperative. That's the one. Kindly protect us for at least no coercive action. I humbly pray. Otherwise, I would not have praised it so much.
Okay. Steve. Please think that too, because this repatriation cannot be done in this way. Yes. Regularization was affected. Registrar also.
Yes, sir. For 2020 were regularized.
Yes. Interim protection for the time. Notice. 2 weeks after the vacation.
30th June. 30th June. 30th June. Item 37.
37, the Lordship, while issuing notice, has formulated a question. By order number 2 dated 30th of March.
37, appearing today, that's what makes. Lost on it. Another day and according to yours.
Why? The notice does not indicate that what questioner we have formulated.
Yes.
The point is a pure question of law.
Yes, I have seen.
Tomorrow, address?
No, I don't, next week.
Tomorrow?
Next week.
What is the difficulty?
I will tell you next week. I have some problem. Next week.
No problem. Today argue.
I have not seen him. I have just engaged me. Anyway, next week.
Next Monday. Next Monday.
Interim order may be extended.
Yes.
That has lapsed in the meanwhile.
Yes, interim order is extended till next date.
I was disposed of.
It was for 3 weeks. That may be extended.
We are extending it till the next date.
This is the order where your lordship's order is going to be stayed by law. And the order passed by the executive.
No. Question is that once it is disposed of, whether any further thing can be done. There are 2-3 judgments of the Supreme Court in this line. You come ready.
You see that? What
You come ready. How far? 152 is one of the remedy. Review is another remedy. Whether the court can adjust his order, that will be considered. Come on Monday.
Direction will to implement the order.
Just say whether that can be
To
done.
implement the order only. I don't know.
Let us see.
No change.
Let us see. Come on Monday.
Order passed by
11th May.
single judge.
Yes.
Implemented much prior to the interim order passed by this honorable court.
Yes.
So
By the
that
state.
was not difficult. If it is already implemented. Yes.
Item 38.
Yes. Review. Whose order?
There is a delay of only 1 day.
Notice has to go. Even a day.
Government is there.
Give him a notice.
Yes.
Service next Monday.
11th May.
Record that he appears. Services will be affected in course of this day. Give him a copy.
Item 39.
That's item 39. There is an application for recall your lordship's order. I have filed an application if your lordships can have that.
Serve the copy on the other side.
I have given the copy.
Did you receive the
This
copy?
matter may be taken up along with writ appeal 491 of 2008.
Sir, he is asking for a recalling of an interim order.
Because the earlier order was passed based on the judgment.
Where is the order which you want to recall?
Yes.
Which order?
Your lordship may see by application 3339 of 25 minutes.
Where is that application?
Yes. Your lordship may see that order that's at Annexure R by 1 at page 12.
Huh?
In that
Let's
application.
This is flexing. Which order? Order dated?
Order dated 27/10/2022 in WA number 490 of 2018.
Passed by which bench? You say your lordships, that's why we thought.
Well,
Say the earlier or preceding bench.
is the preceding. I stand corrected. Preceding.
So what was the composition of the bench?
But Honorable the Chief Justice, then Malus and Malus Justice.
So it has been assigned to us
Yes, that is how it has come to your lordship.
by assignment. Is there any assignment which is given?
Possibly because Malus Justice Raman was part of the bench. So it has-
So that does not mean there must be an assignment to the bench where Justice Raman should be a part of it. So that was 2019. When application is filed by you?
Well, this has been filed in 25 minutes.
There is an
The
assignment
order
which
is
is assigned,
being-
but it has to be assigned, otherwise we can't take up with it. It has to be assigned to this bench, otherwise it cannot be. It appears that the instant application for recall Condonation is there.
Yes.
Service 1 week after the vacation. 1 week after, serve the copy. 41.
Item 41.
Serve the copy.
I will solve the copy.
You serve the copy first.
My predicament is the contempt application is pending, the contest.
And while you are delay, you have to serve the copy. Serve the copy.
I'm serving today.
Serve today.
She is appearing.
Next week, we'll take up.
Item 41, 11th May.
She appeared for the practice service of the copy in course of this day. Better to list on Monday. Next.
Item 42.
42 lordship only. Requisite to be accepted lordship, sorry
Out of time.
lordship.
Look, the requisite put in out of time.
I am appearing for respondents, 3 respondents. The others.
There is only one respondent, 43. Hiron Kumar Sasmal, that's all. No 3.
There is a delay of 25 days.
Service has to be, others are also there.
That's right.
But the cross title here does not is,
I could have.
why you are not, why it is showing others?
So you will show.
What?
In the cost, it will show.
Notice is.
So you'll have to serve, including him, others also by post. 1 week after vacation. Next.
Item 44.
Record his appearance, appears for such and such. Service of copy in course of this day. Give your name, juniors and seniors both name.
Item 44, I am on VC Milord.
Yes, service.
Service of
Union of India.
Union of India. We have served to a private party.
Yes, you filed, but you have to serve a copy of the condonation application.
Can this be heard, Milords? I will serve it.
2 weeks, 2 weeks. Before vacation. 2 weeks service of the Union of India.
Obliged.
18th May. Item 45.
Yes.
Their notices had gone on the question of limitation. They have appeared. There is a delay of 80 days in filing the appeal.
What do you say?
I was praying for next week, Your Lordship. And the delay of.
Come on Monday, 80 days, I understand.
Just explain. So we've gone to the Honorable Apex Court against the order of the Honorable Single Judge. We were relegated back, Milords. And in fact,
we understand that's the ground that it is a sufficient cause which you have made out for delay. He asked for an adjournment. Come on Monday. Next Monday, we are keeping this matter.
Item to 11th May.
Yes.
Item 47.
46. 46.
Sorry. 46.
The service already affected.
We have already
Reply already filed.
My objection to the application.
So these are leave to file an appeal application. Leave to file an appeal application.
Yes.
You are a third party to the proceedings. You are a third party to this.
Yes, I am a third party.
Has he filed the counter?
Yes, he has already filed a counter. I am inviting your lordship's attention.
You want to file a rejoinder?
Not necessary.
Not necessary.
Inviting your lordship.
Today I have filed this, it may not be on the board.
Which one?
That objection.
We will take it from you.
Yes.
Your lordship may take the objection in IA number 7.
Why you are an affected person?
I am an affected person because I am the lessee in respect of the land, which has been granted to me by Paradip Port Trust. I am putting up an industrial establishment there. Now, this person claims that I am the I used to be the erstwhile landowner. My ancestors were the erstwhile landowners. Their name has been illegally taken out from the record of rights. And accordingly, he made an application before the Settlement Land Records Commissioner for correction of his records.
Correct.
And in the meantime, he had also filed a suit for injunction against us.
Yes.
In that suit for injunction, the plaint was rejected. It was, and he was totally conscious that I am a lessee in respect of the land. Despite that, he never included me as a party. I was not heard through and through. Now, my lord, he clearly admits that my rights have been substantially affected. That is in IA number 711 of 26. He files a counter affidavit, paragraph 2, your lordship may take.
Yes.
The second sentence.
Yes,
It is
counter
correct.
affidavit. Give, I have invited his copy to be given.
Office copy, that is not.
No, I just wanted your copy.
I have already read.
Yes, that's all.
Your Lordship, paragraph 2, second sentence. It is correct that the appellant was admittedly not a party to the writ petition being WPC number so and so, nor was it included at any stage of the said proceeding, despite being a necessary and proper party whose rights stood.
I am not getting it. Paragraph?
Paragraph 2, my lord.
Yes.
Paragraph 2, second sentence.
Yes.
It is correct that the appellant.
No. Sorry. This is IA number 700.
Okay.
Oh, he has one copy. You have given.
Yes, I have only one.
It is.
Your copy you have given.
No, what you gave me a counter affidavit.
No, this is another IA.
Oh.
I didn't mark.
He has filed 3 counters.
Yes.
3 objections. Second sentence in IA numbers.
Yes, it is correct that.
Correct that appellants were admittedly not a party to writ petition being writ petition.
I understood. Nor was it included
at any stage of the said proceeding, despite being a necessary and proper party whose rights stood directly.
Then what remains? Then leave has to be granted.
My lord, here is only submission. I have not filed the writ application. The lessor has filed the writ application. Omitted to make the lessee a party.
It was against his application before.
So who was the writ petitioner?
Writ petitioner Paradip Fort.
Paradip Fort was there. My lord, all these submissions, our independent writ appeal is also there tagged along with this. So essentially the order of the single judge is under challenge. Your lordship can examine it in either of the writ appeal.
What examine in either of the writ appeals? Is he not entitled to prefer an appeal?
Yes.
He is widely affected.
I'm not.
We are simply disposing of the leave to appeal.
Yes.
Saying that yes.
My humble submission there.
There is nothing for submissions.
The writ appeal is not maintainable.
First to leave to appeal, then the maintainability.
The question is that when the writ appeal is not maintainable at all.
Why writ appeal is not maintainable?
Well, the revision has been filed.
What revision?
Under section 15B of the Survey Settlement Act, it is special statute, and that has been allowed.
Then the writ petition does not lie.
Yes.
Well,
226 doesn't lie.
Yes.
Well, so 226 was invoked. Against the past with the single bills they have come.
Against the single judge, they are invoking the jurisdiction under Article 227.
Which
where these are not put in a full jail.
No, I understand. Where is a 227 jurisdiction? Tell me.
Well, can you see the impulse order? For a moment, can you see the impulse order?
Today only your lordship has seen those division bench orders.
I have seen that. Sashwati or something, the judgment is there.
Here one thing is clear. Unless it is a civil court, writ petition under 226 is still now that is the law.
Correct.
So far as this case is concerned, there is no dispute.
Which order was assailed?
Order of the authority under the Survey Settlement Act. It is not
then it is 227 always.
That is always under Code of Revenue. These are always and writ appeals are always made.
Can you see?
There is not 227. He is neither a court nor a tribunal.
Yes.
But the
227 does not lie.
My friend Mr. Mishra also might have filed many writ appeals.
But the main judgment of the Supreme Court has held there. A writ appeal is not maintainable against a special statute order. In Article 227. That is the judgment of this or
no? 227 lies when? 227 can be invoked by the High Court against the order of the court.
Yes.
A tribunal. If it is neither a tapping of a court nor a tribunal, 226, how can it be the exercise? No, is not there. Yes. There is an application seeking leave to appeal.
Objection to that extent also. Another objection. That nowhere it has been disclosed that the lessee is there.
Sir, you have admitted that he is a necessary party?
In the writ application. Because he has...
Obviously, and this order emanates from a writ petition. Yes. What is the other 40? What is the another matter? 40? 47?
Yes. Item 47.
Service condonation. 1 week after. Deputation. 48?
Yes, sir. There is a noting that already the AD has been served by law. There is a delay of 4 days.
Who is representing the Steel Authority of India?
So next time there is nothing.
Who is appearing?
We have received the wakalat now. That's what will be appearing. We haven't filed a wakalat.
You just receive a Vakalatnama, next Monday we are keeping it and conclude the delay.
Monday I'll not be here.
14.
It will be a 1 minute affair.
Mal.
We'll record you.
Well, I have a matter.
In Cuttack?
Otherwise, I'll be online, Mal.
Yes, online. Just for sake of 1 minute. Second matter. It will be disposed of.
11th May.
Yes. No. When 11th May? Yes. 49.
Item 49.
There's a delay in it.
I know, but I was just today morning mentioned 180 days is the lordship just additional actually.
What?
Minimum period of blocking portal is 180 days.
Now 180 days is over.
Recommendation. Can you?
Why you are not opening?
Let me check out.
No, yesterday copy the lordship can you see the annex?
Yes, period is over. To be done.
Take it up on Monday.
Tomorrow.
Take tomorrow as a first, whatever. It can be disposed of within a minute. Unnecessarily don't.
Now,
180 days, he has a grievance. It was limited for 180 days. 52.
Item 52.
52 for the application. I seek adjournment. And seek an adjournment by notice.
After vacation, that comes. Yes, after vacation. Seek an adjournment.